Here.
She's downstairs. She can't come upstairs. She has panic attacks and she don't ride elevators. She'll freak out. I'm her son.
Is she in a wheelchair?
No, she's not in a wheelchair.
But we have a stairwell.
She climbed the stairwell back in January, I think it was, and almost passed out.
Okay. A courtroom in Michigan just exposed something that should terrify anyone who's ever hired a lawyer to protect them. An attorney stood before a judge, denied wrongdoing to her face, and within minutes his own words proved otherwise. The case involved an eviction, a wheelchair excuse that turned out to be false, and a woman who couldn't even remember signing the documents filed under her name. What this judge uncovered would unravel an attorney's entire strategy in real time. And by the end, you'll understand exactly how far some lawyers will go to win and what happens when a judge simply refuses to look away. The case was Hamilton Road versus Claude Miller and Betty Miller, a landlord-tenant dispute that had already gone to trial.
Hamilton Road versus Claude Miller and Betty Miller. Can I have appearances, please?
Good afternoon, Your Honor. Gene Turnwald on behalf of Hamilton Road, a representative and seated in the courtroom.
Good afternoon, Your Honor. Darwin Fair on behalf of all the defendants.
Hamilton Road, the property owner, had won. The court awarded possession after determining the actual occupants weren't even the people named in a related court of appeals case. That should have ended things. Instead, weeks later, a new name started appearing on filing after filing. Betty Miller, the wife of the original defendant, submitting documents in what's called pro se, meaning representing herself without a lawyer.
After the trial only, for the very first time, Betty Miller started showing up in the caption of the pleadings. And I believe this was done intentionally to muddy the waters so they can argue in front of the circuit court judge that, oh yeah, Betty Miller is now the same party as the Court of Appeals. She's never been a party. She is the only one who has filed an appeal. There is no claim of appeal by the Davisons. There is no claim of appeal by the estate of Claude Miller. Only Betty Miller,
on paper, a private citizen exercising her right to petition the court. In reality, opposing counsel believed something very different was happening.
The court is being intentionally misled by Mr. Fair. Trial in this matter happened on January 31st. The court awarded possession to Hamilton Road based in part because the occupants were not the same as the plaintiffs in the Court of Appeals case. Since then, a number of filings have happened that are Betty Miller in pro per. Betty Miller
Attorney Gene Turnwald, representing Hamilton Road, stood up and made an accusation most attorneys spend entire careers avoiding. He told the judge, on the record, that another attorney, Darwin Fair, was ghostwriting motions for a woman who was never even a party to the case, then having her file them as if she'd done it alone.
The Court of Appeals case, which is also ironically drafted in pro per, has Betty Miller as a party. So there's a unique advantage adding her as a party after a trial to mislead the circuit court judge.
Why would that matter? Because if Betty Miller was never named in the original eviction, never served a summons, and never appeared as an occupant, she legally had no standing to file anything on the case's behalf. Adding her name to the caption after the fact wasn't housekeeping. It was, in Turnwald's words, a way to mislead the circuit court into thinking she was the same party already fighting the case on appeal elsewhere.
However, the Court of Appeals case, which is also ironically drafted in pro per, has Betty Miller as a party. So there's a unique advantage adding her as a party after a trial to mislead the circuit court judge.
Here's where it gets personal, when the judge asked where Betty Miller actually was. Since a hearing had been scheduled specifically for her motion, she was told Miller couldn't come upstairs because of panic attacks. The judge asked a simple, practical question: was she in a wheelchair? No. Was there an elevator? Yes. The excuse didn't hold up, and the judge wasn't going to let procedure bend around a story that kept shifting. Then Darwin Fair spoke up, still without ever having filed an appearance representing Betty Miller. That detail matters more than it sounds. In court, an appearance is a formal document that tells the judge and everyone else exactly who a lawyer represents. Without it, an attorney has no standing to argue on someone's behalf. Legally, they're a stranger to the case.
That's fine.
Well, you can't, because you gotta, if you're gonna represent someone, you need to file an appearance. And you can't do what I suspect you're doing, which is try to hide behind the 8-ball and draft motions for someone to file on their own and then show up to court.
Well, the judge stopped Fair cold. Everybody doesn't get to decide when they may. I'll decide who may on today. One sentence. No shouting.
Your Honor.
Your Honor, if I may, Your Honor,
If I may.
if I may, those.
Oh, Mr. Wait a minute. Everybody doesn't get to decide when they may. I'll decide who may is on today. I don't have an appearance from you, Mr. Fair, on her behalf.
Just a judge drawing a hard line that would define the rest of the hearing. What happened next is the kind of moment that ends up clipped and shared for a reason. The judge asked point blank whether Fair had drafted the paperwork Betty Miller supposedly filed on her own. Fair insisted he'd never mislead the court, but the pleadings themselves said otherwise. They stated in writing that the documents were prepared with the help of an attorney. The judge simply read it back to him, primarily drafted with your help, correct. Fair had no real answer. That's the trap of paper trails. You can deny something out loud, but you can't argue with your own filing.
Do you want? Okay, I'm going to ask her under oath when she gets here if she drafted this.
No, Judge, it has it right here that it was done with the help of a lawyer. I did help her as a lawyer. It has it on the pleadings that must be in the pleadings that the document was drafted with the help of attorney. It has it right there in her motion for reconsideration.
Okay. Primarily, it was drafted with the help of you, correct?
If you've ever worked somewhere a manager broke the rules everyone else had to follow, this will feel familiar. Power doesn't usually announce itself. It just quietly assumes the rules apply to everyone except the person holding the pen. The judge then called Betty Miller directly, under oath, and asked what she'd actually filed. Her answers told the real story. She didn't know the motion's contents. She didn't remember signing anything at that courthouse. She confirmed a lawyer had filed something for her. She just wasn't sure.
I can hear.
What?
Okay. And so you filed a motion for reconsideration?
Yeah.
Okay. You're not sure what you filed?
I was at the court, but I don't know exactly. No.
What motion was it?
Okay, what motion was it?
A motion. It says defendant's motion for reconsideration.
This is the legal concept of standing in its rawest form. The right to bring a claim belongs to the person harmed, not to whoever is willing to sign the paperwork.
I completely understand your position.
Okay.
You believe that the foreclosure was invalid and she should be the lawful owner of the property. Until the court says that, she doesn't get to act like the lawful owner of the property. You got to get a court to make her the lawful owner. You can't, by virtue
Betty Miller, by her own admission, barely understood what was being filed in her name.
Well, I'm asking you because you haven't been able to come upstairs. So did you go to the 5th floor to file this?
No.
Okay. So how did you file the motion?
I didn't sign no papers.
The judge's ruling followed the facts precisely. The motion to strike Betty Miller's filings was granted. She was never a party, never an occupant, and had no legal standing in this eviction.
And lost.
Okay, I'll address the motions. There was a motion to strike the filings by non-party Betty Miller for rent to issue. That motion will be granted. Betty Miller is not a party in this matter, nor was she ever an occupant in this eviction landlord-tenant proceeding. So that motion will be granted. The motion for reconsideration is not properly filed. Betty Miller can't file a motion for reconsideration for the occupant, Mr. Davis, being evicted.
Her motion for reconsideration was denied.
Something from Ms. Miller. We got multiple filings from Ms. Miller. Then you appeared. That's not appropriate. You're trying to attach someone to this case who's not supposed to be attached to this case to get that order outside of doing it the appropriate way. So for that reason, the motion of reconsideration is denied.
Your Honor, we'd like the writ to issue.
And critically, the appeal Fair had attempted to file had been submitted 4 days before the judgment was even signed. Under court rules, an appeal must follow a final order, not anticipate one. It was procedurally void from the start.
Your Honor, a claim of appeal was not timely filed. We're being misled on that. The trial in this matter was January 31st. Your Honor signed a judgment landlord-tenant on February 16th. You have 10 days from February 16th, according to the court rules, that Mr. Fair wants to argue to file a claim of appeal. They didn't file one. They filed one on February 12th, before Your Honor even entered the order. That's entirely improper. It says an appeal from the order must be filed after the order is entered, not 4 days before.
Here's the question worth sitting with. If an attorney genuinely believes he's protecting a vulnerable client, does the end ever justify bending the process? Or does that instinct become exactly the kind of shortcut the system exists to prevent? The result wasn't a clean, satisfying ending. Fair wasn't disbarred. No sanctions were issued that day, despite Turnwall requesting them, a rare move from a lawyer with over 3 decades of practice. The judge granted the writ of restitution, allowing the eviction to proceed, and openly predicted more filings and more delay tactics were coming.
Circuit court judge. That was all done in pro per, but I suspect Attorney Fair drafted. I suspect this because we've located very similar cases in the Court of Appeals where Attorney Fair has argued and lost the identical issues. You have to pay it either to the plaintiff, Hamilton Road, or the Registry of Deeds. And he's argued these cases on the Court of Appeals, and he's lost.
The system caught the maneuver. It didn't fully punish it.
I'm positive that you're going to put in a request for a writ. I'm positive Mr. Fair is going to go and file a motion to stay the writ and then file another filing. I'm positive that we're not done yet. I'm positive of that. But nonetheless, as it relates for today, there will be a order for a writ to issue, and I will note on the record that the bond appeal, let me find this motion to reconsider. Motion to reconsider the bond appeal is denied as Betty Miller
What this hearing reveals is bigger than one eviction case. Courts run on trust that filings are honest, that attorneys represent who they claim to represent, and that procedure isn't a tool for confusion. When that trust is tested, it takes a judge willing to ask uncomfortable questions directly in open court to someone's face to hold the line. Accountability rarely arrives as a dramatic verdict. More often, it looks like a judge simply refusing to accept an answer that doesn't add up. If there's a courtroom moment, a case, or a legal showdown you want broken down next, drop it in the comments below. Subscribe and share this video, because understanding how the justice system actually works, one case at a time, is how we all become harder to fool.